This is a real Claude-drafted research memo, anonymized, but otherwise unedited. Somewhere inside it is a fabricated citation. We're going to find it the way a senior partner would, reading it the way you'd read an associate's first draft before it goes anywhere near a client. Not skimming. Checking. Here's the passage, a memo on the enforceability of a non-compete clause. The enforceability of post-employment non-compete provisions turns substantially on reasonableness as to scope, duration, and geography. Courts have generally upheld restrictions limited to 12 months where the employer can demonstrate a legitimate protectable interest. Then 2 citations. Harrington versus Delford Consulting Group, the lead authority, the case the argument depends on. And Whitmore Holdings versus Castellan, cited second, reinforcing the broader trend rather than carrying the central point. 2 citations. One of them is not what it appears to be. Start with the lead case, because that's where most reviewers start. Harrington versus Delford Consulting Group. Run it through Westlaw. It's there. The holding matches what the memo describes, an 18-month restriction upheld on the basis of a senior client-facing role with pricing access. This citation is accurate. Claude got the central authority right. That's actually typical. The citation an argument depends on tends to be correct. It's the next one that needs closer attention. Whitmore Holdings versus Castellan. Not the lead authority, the supporting citation. Reinforcing the trend, not carrying the argument. It's also the one most reviewers check second, if at all, because by the time you verified the lead case, the instinct is that the hard work is done. Run a case search. No result matches this name and this fact pattern in any reported jurisdiction. There is a Whitmore Holdings case, but it's a commercial lease dispute. Nothing to do with employment restraints. This is not the case the memo describes. Whitmore Holdings versus Castellan does not exist. Not misquoted. Not a real case applied to the wrong facts. A case that was never decided, by a court that never heard it, invented to support a sentence that sounded right. And it sat exactly where it was least likely to be checked, the supporting citation, not the lead. It's almost never the lead case. The fabricated citation in this memo was not load-bearing. The argument doesn't depend on it. It's reinforcement. A sentence that sounds like it's adding weight to an already established point. That's the tell. The lead case gets checked because reviewers naturally scrutinize the citation an argument depends on. It usually checks out. The supporting cast gets skimmed because it reads as low stakes, the assumption that the heavy lifting has already been verified elsewhere. That's exactly where fabrication hides. A model under pressure to sound comprehensive will sometimes invent a case to round out a point, not because the argument needs it, but because the sentence reads better with a second citation. Verify the margins harder than the lead. What to run on every draft? Verify the lead case first, but don't stop there. It usually checks out. That's the beginning of the review, not the end. Treat every supporting citation as unverified until checked. No exceptions for citations that sound right or reinforce a point you already believe. And run every case name through Westlaw, LexisNexis, or Fastcase. Not a Google search, not asking Claude to double-check itself. A proper research tool, every time. This is a habit you build into how you read any AI-assisted draft. A complete verification system, the protocol for firm-wide deployment, the supervision checklist for junior use, is a different and more comprehensive thing. That's coming to this channel separately. The fake case is almost never the lead. It's the supporting cast, the citation reinforcing a point you already believe. Verify the margins harder than the lead. That's the read from this teardown. Future teardowns will cover a memo where the fabricated case is load-bearing and the rebuild is real work. A contract review where the model misreads a clause rather than inventing authority. And a brief where the fabrication is a misattributed quote from a real case. If you're serious about a complete verification system for your practice, we're building one. More on that soon. That's the episode. See you in the next one.